Workplace bullying is far more common than most people think, and in some cases can legally amount to constructive dismissal. In this video, we're going to be explaining how you can recognise bullying within the workplace, how to prove a case of constructive dismissal, and understanding what your rights are under UK employment law. I'm Simrat from Monaco Solicitors, and we're here to help employees like you seek the justice you deserve and compensation. Let's begin by going through some examples of what could amount to workplace bullying. So, bullying at work often includes spreading false rumours, verbal abuse or insult, micro-supervision, being excluded from team meetings or external activities, and constant criticism or being set up to fail. These behaviours can severely damage your mental health and lead to time off from work. Actually, it can affect you long term and your future career progression. In fact, studies show approximately 35% of individuals within the UK have reported workplace bullying, and many more suffer in silence. This kind of treatment could also be sometimes classified as workplace harassment, especially if it's related to a protected characteristic such as race, age, sex, or disability under the Equality Act 2010. So what happens if you face this kind of bullying? Whilst there's no single law that prohibits bullying within the workplace, you may be able to bring a legal claim under a claim of constructive dismissal. In order to be eligible for a claim of constructive dismissal, you do need to have continuous service with your employer for 2 years. However, most noticeably, for constructive dismissal, your employer must have breached your contract of employment, and ultimately, you must have felt forced to resign because your working conditions are intolerable. For example, if you've raised these concerns in regards to the bullying to your employer and they've done nothing to support you or prevent it, or in fact, they've retaliated against it, you may have a claim for constructive dismissal. Unfair dismissal is typically where you've been dismissed without good reason, or the process has not been followed correctly in regard to your dismissal. To build a strong case, you'll need evidence. So what amounts to evidence? This can typically be emails, any correspondence between yourself and the employer, any witness statements that you're able to receive, and a clear log of what has occurred. This leads me into my next part, a timeline. It's really important that you keep a timeline of events of what has occurred, and also any instances where you've raised your concerns in regard to the bullying. Now, lastly, you need to be able to prove that you are unable to continue working at your current place of employment because of the poor treatment that you've suffered. If your employer failed to act on your complaint, or in fact worsen the situation, you may be eligible for a claim, but you must act quickly. When it comes to employment law, there is a strict 3-month minus 1 day time limit in which you will need to file your claim with ACAS from the date that you resigned. Please do make note of this, as it's extremely important. Here at Monaco Solicitors, we'll be able to guide you through that, as well as help represent you in your case of constructive dismissal. Let's look at an example of how this can play out. Let's take a case study of Emma. Emma is a marketing executive who had been employed for over 2 years. Emma has been complaining of bullying within the workplace. Treatment she's faced is including being excluded from meetings, being spoken about by colleagues, and just general micromanagement. Emma has raised her concerns to HR by way of a formal grievance. Unfortunately, the employer has decided to not support Emma and has in fact called her too sensitive. Emma decided to resign and, with our help, seek a settlement under the claim of constructive dismissal. If this sounds like your situation, remember our key takeaways from today. Document everything. This includes emails, any letters you receive from the company, any witness statements or records that you have from your colleagues, as well as any general correspondence regarding the concerns. Make sure you raise your concerns. Speak to HR or start the process of lodging a formal grievance raising your concerns. Importantly, seek legal advice. Speak to an expert before you resign or take any further action. And lastly, consider a settlement agreement. From what you face, there may be financial compensation that you can seek for your claim. If you need help in understanding whether or not you qualify for a case of constructive dismissal, get in touch. We will be able to review your case and advise you on your next steps. At Monaco Solicitors, we specialise in helping employees take legal action and negotiate the best outcome. If this video helped you, don't forget to hit the like, subscribe, and share this with someone who may need it.